person who did the crime. I want you to think of the innocent person. And what I hope I'll be able to show you, what I believe, is that because our field came out of police laboratories and the emphasis was find the person who did the crime, there are a lot of accidental biases that work against the innocent person in the system. Okay. I would like to introduce you to one of those people. This is Terry Tawley, spent 39 years in prison in Georgia in the United States. I worked on his case. I didn't have that much work on his case, but I worked on his case through the Georgia Innocence Project. There was a rape. We did some DNA analysis. He was excluded after he was in prison. We excluded him from the rape. Everybody agreed. And I thought he would go free. And then the lawyers at the Georgia Innocence Project said, well, there's a problem. I said, what's the problem? Well, he had 4 rapes that he was accused of and convicted of. And in one case, he gave some sort of incriminating statement. And so even though we undid one of them, there were 3 more. It took the cooperation of new prosecutors who looked at the evidence fresh, and the Georgia Innocence Project lawyers, and a little bit of DNA work from my lab to convince everyone in the system that Terry Tawley should be freed. But can you imagine going through the accusations, the loss of job, the family members who no longer visit you in prison? That happens to everyone with 39 years, not being able to go to the funerals of your parents, etc. There's another gentleman, Stephen Pina. He's still in that purgatory. He's been freed from prison, but they're deciding whether to retry him. He has to wear an ankle bracelet, electronic, that he can't swim with, for example. Even though his conviction was overturned, he has to worry every day what the state's going to do. Gilbert Poole, and all 3 of these folks, we worked a little on their DNA. My partner, Janet Lane, worked on Gilbert Poole's case a bit with the Michigan Innocence Clinic, and they also had a conviction integrity unit, I think involved with this. I'm not sure. It took a lot of people. He was freed in 2021. All of these pictures are from an annual conference that we have with people who work on innocence cases and some of the clients that we've freed. This is a statue outside of the Connecticut Crime Lab. Henry Lee, some of you may have heard of, a mentor of mine and an early person who brought DNA into solving crimes. And he had this statue put outside of the lab, and all the workers saw it when they went in every day. He didn't want to hire people who said, I'm trying to give the victim a voice, or people, maybe from my groups who I want to, free the people who were wrongfully convicted. He taught us, and I just knew him, I was never formally a student, but he taught us to let the science speak, that was our job. And John Butler, I really appreciate going after John Butler. I teach from his textbook, and he's a great teacher, and I appreciate that. I think that in his slide set where he talks about the experience and training of an analyst, I think we have some problems there, because we should speak for the science. I should not speak for my anecdotal results over the year on crime cases I've worked. There's no proper control for most of that evidence processing. There is in the PCR, but in terms of knowing, for example, activity level, I don't think we're there. I think it's misleading to say, as a DNA analyst, that I know how DNA got somewhere. I think the science says so far, DNA tells us who may have contributed DNA. It does not tell us how. And what I say to analysts who think that they can do activity level propositions, I say, give me your toothbrush. I can put you on any piece of evidence. You want me to put a little DNA? You want me to put a lot of DNA? You want it to look like you spit on it? I can put you anywhere I want. And I don't think DNA analysts should be weighing in on activity level. I think we can refer to studies done in the field, but I don't think we have any mental ability to tell how DNA got somewhere. So that's limits of the science, in my view, for example. Okay. These are quotes from Galileo. I like to use Galileo because my father was a physicist, and all we had was books about math and then biographies of great physicists. So Galileo was one of my heroes growing up. And he said, by denying scientific principles, one may maintain any paradox. You can have paradox in a romantic relationship. You believe someone's perfect. You can have paradox in religious context, the Trinity of Christianity, for example. You really can't in science, and that's what Galileo was teaching us. In questions of science, the authority of 1,000 experts, he was talking about, people who carry credentials, is not worth the humble reasoning of a single individual. And that's what I'd like us to focus on, reasoning. Count what is countable. Measure what is measurable. What is not measurable, make measurable. One of the comments I had on the NIST reports that John Butler was referring to when John made himself available publicly for us to comment was, I don't think labs should extrapolate beyond measures that they've actually tested. If you've tested your DNA down to 50 picograms in your validation, then that's what your limit is, 50 picograms. You can't, in my view, extrapolate down below what you haven't validated. So count what is countable. You want to go lower? Well, do that, measure it. The number of contributors in a mixture, a lab has to validate that. And if you do it for 4 contributors, can you also do it for 10? If you want to, validate it. Science proceeds more by what it has learned to ignore than by what it takes into account. And I would say we should ignore opinions outside of science. I don't think as a DNA analyst, I should be allowed to make common sense opinions from the stand. I think I should say that's a question for the jury or the judge, triers of fact. Okay, there's our Galileo. And I like to use him also because I worked a little on Amanda Knox's case in Italy. And I wanted people to know I'm not saying anything bad about Italian science. I revere Italian science. Okay, when I got into forensic science 20-something years ago, I was a molecular biologist, and I wanted to know what the error rate was. And I asked at a meeting, what is the error rate at the DNA lab at the FBI? I asked the head of the FBI lab at a talk. And he said, 0. And I laughed and said, where did you get such a small ruler? It sounds like you're not measuring anything. So I tried to put it in a way that people could understand. If we measure the justice system by the number of truly guilty people convicted, did we get the bad guy? That's the purpose of police science. If that's what we measure, then the Salem witch trials were an astounding success because more than 100% of the witches were convicted. Obviously, what we have to do is measure our error to determine our success and have confidence in our conclusions. So we began to study cases that had been overturned using DNA. And this was a study we performed in 2010, looking at the first 194 US DNA exonerations. And I did this because I got great help. They did really the heavy lifting, Emily and Olga. I did this because we'd go into court and a judge would say, well, you want to test, uh, for innocence, you want to test fingernails. How many people have ever been freed using fingernails? So right in the abstract here, you can see 5% of these cases used fingernails. We looked at cigarettes, clothing, what types of DNA testing was done. And that's again because controlled research is the biography of science and historical records of cases and what was tested. That's the biography of science. That's what we should testify to. Not my particular biography, but the biography of my field. Here's the first problem, and I'll talk about as many of the problems as we have time for. By the way, my laboratory is your laboratory. Come and visit us at Boise State in Idaho, or email me if there's a question or you want to collaborate or you've identified an issue in the system you want to chat with somebody about. But I'll talk about some of the problems that I've learned over the years. The absence of evidence is not the evidence of, fill in the last word. So we're taught in forensic science, I was taught, the absence of evidence is not the evidence of absence. I had a problem with that, and I didn't know why for many years. Why did that bother me? Well, here's a case example. There were 4 vaginal swabs from a alleged sexual assault that were taken. And here it said insufficient male DNA for further processing. Absence of evidence. Doesn't mean anything. We can't say anything happened here. The attorney asked me, it says insufficient male DNA. That means there was some male DNA in this complainant's vagina. And I said, I'm not sure. So we went to the quantitation and it had a 0 quant. So it should be no male DNA was found. Now, if you found the victim, her own DNA, her vagina, and you found no male DNA, which side does that support? The defense or the prosecution? Well, it supports the defense. The controls all worked. The defense allegation is, I didn't do it, this man who's accused. This evidence supports the defense proposition. What it was reported as was inconclusive, not an exclusion. Now think of your innocent nephew. Let's say it was a nephew, a male accused of vaginally attacking a child who can't speak, too young. And they extract, the mother says, let's say that the vagina was red, and they swab DNA and they find the baby's DNA, no male DNA. Does that help your nephew prove that he didn't do this, that he wasn't there? Of course it does. It is not the absence of evidence. It is evidence of absence. And so we should be very careful about these inconclusive terms. They are inconclusive to finding the right guy, but they are conclusive in supporting one of the alternative hypotheses, in this case, the defense hypotheses. So inconclusives are a problem. This has been shown even more so in shell casing analysis and pattern matching for shell casings. An inconclusive result was described in the proceedings of the US National Academy of Sciences, a respected journal. That inconclusive is actually indication that the guns didn't match, because the examiners are more likely to call it inconclusive when you have laboratory tests of guns that fire several bullets or 2 different guns. The analysts are very good when they make a definite decision, but they make definite decisions about inclusion, and they use inconclusive more often for the known laboratory exclusions. Be careful about inconclusive. Be careful about the absence of evidence. Negative results are the evidence of absence. the absence of an embryo. That means you're not pregnant in a pregnancy test. The absence of cancer, no need for a mastectomy. The absence of viral DNA that lets you stay home for a week, COVID, negative test for COVID, that's all absence. And there's evidence for it, a negative test. So the crime lab is testing a hypothesis about foreign DNA. They have generally a suspect's DNA. Let's take the example, right? A reference sample, and then they have the evidence. The hypothesis is these two will match. You either have data that supports that or data that refutes that. If the controls work and no foreign DNA is found, that is a valid refutation of the hypothesis. It is an exclusion if everything worked. The suspect's DNA is excluded in my example, as well as all males are excluded from that sample, from that swab, but that swab was taken as evidence. How does this work in a court? Well, this is a case I had to review. The prosecutor is asking a DNA analyst about the lack of the suspect's DNA on the evidence and trying to play it down. Say it's not important that the suspect's not on the evidence. And the prosecutor asks, I'll let the translator read it. Everybody else can read it for yourself. The DNA analyst says, even if there's not DNA on a sample, that doesn't mean that the person wasn't there. And so the prosecutor literally says, so the absence of evidence is not the evidence of absence, so to speak. Correct, says the DNA analyst. Thank you, says the prosecutor. That's all the questions I have. And this wasn't cross-examined in the way that I'm encouraging you to examine your own conclusions about negative results and being very cautious about calling things inconclusive, giving them some whatever weight you want to give to your conclusions, whatever confidence you want to give to your conclusions, but being careful about that inconclusive. And again, I'm speaking from the perspective of the innocent accused today. The FBI has put the second footnote here that insufficient DNA, this is from an FBI DNA report, insufficient DNA, quality or quantity, can affect the ability to generate a DNA typing result. But it's not an absolute determination that an individual did not come into contact with an item of evidence. What if they said this about your nephew? They said maybe there wasn't enough DNA, but he did assault this child. This negative result is not an absolute determination. Well, shouldn't they also then have a footnote for their positive results? A positive test is not an absolute determination that an individual came into contact with an that word absolute is only used for the negative here. It could be somebody took my toothbrush with a positive result, and so it's not an absolute determination. A positive result is not an absolute determination. There should be another footnote. Why is this important? Well, this man getting his head kissed by his mother, Vera, is Christopher Tapp, one of my best friends. He recently died, and it's been investigated as a homicide, and it's troubling to see his photo for me. But Chris was a guy whose case I worked on for more than a decade, and who many people worked to free. And he got out, but what he was accused of was rape and murder. They had semen evidence from the victim. It was someone else, but they used it at Chris's trial and said, hey, Chris isn't there. He must have done it with someone else. His DNA is not there, but that absence of his evidence is not the evidence of his absence. So he spent 23 years under this false accusation. We were finally able to free him, clear his name, and he got compensated. We used forensic genealogy, one of the first exoneration that used genealogy We used Y chromosome for those of you who want to know, and we found the last name lineage of the semen left on the dead woman, and then C.C. Moore and the folks she worked with followed that trail and identified him then. He has admitted to it. He's now serving for the murder of Angie Dodge, murder and rape. Okay, what about this activity level that John talked about? He referred you to a paper. John's a great teacher. He always assigns homework. My suggestion, we should all do the homework he assigns. If he says read a paper, read the paper. But I will say that the activity level propositions I have a real problem with. Again, I don't think you can tell if I take your toothbrush and put it on the trigger of a gun or you touched a gun. I don't think I could discriminate between those two by the DNA. We also use a terrible term in the United States, and even though a lot of labs are trying not to say it so much, analysts say it on the stand at trial. Prosecutors and defense attorneys use this term, touch DNA. Of course, all it means usually is DNA that was taken from a sample that had no stain on it, no biological stain. But every child learns from its caregivers at school and at home what proper touch and improper touch is. And if you ask a child, did he touch you? Or a child's complaining about their brother or sister, Mommy, he's touching me. It means hand, right? Maybe another part of the body, elbow or something. But calling it touch DNA for a DNA analyst is implying to the automatic route for our minds that it's touch, it's contact. So this is one of those biased terms. I'd say trace DNA is probably good, or low-level DNA, but never touch. Here is a disclosure from a US FBI expert who was going to testify in a case where I was going to testify. And this disclosure from the lawyer who had this expert from the FBI says that the expert will testify that the DNA is consistent with the defendant having actually handled or touched the firearm with his bare hand or skin. It's also consistent with the toothbrush. It's consistent with the gun being left on the defendant's car seat. It's consistent with a lot of things. I don't think a DNA analyst, any DNA analyst, can tell you how DNA got somewhere. I'm going to skip. These are some basic slides. I'm assuming you guys know where DNA comes from. This just shows, for those of you who might not be familiar, we measure the length of segments of DNA on certain chromosome locations. They're labeled for you here. John Butler talked about, for example, D3. These are the chromosomes. They were named nicely. The biggest one is called number 1. They mistakenly got a couple mixed up at the end. D3 means DNA on chromosome 3, single location, and the 1358th identified. I show my students, most of you are aware, that what we're measuring is just the length of a piece of DNA from mom, the length of a piece of DNA from dad. We get those measurements at 13 or more sites. We can have pretty much an identification of a single person. You probably know the steps to getting DNA, so I'm not going to go through these. It's in the slides. And if you need a copy of the slides, you can email me. I think our hosts also have them. Here's an alternate light source, though. You may be familiar with this. We use a black light, in this case, on clothing, looking for biological stains. This is underwear, obviously, and the photo shows areas that the analyst would want to test or has tested. So John was talking about this source term rather than subsource. Those terms are all very confusing to me. Anyway, the source means that we're going to be looking at the biological fluid. And he had in his slide, and again, this is no criticism of John, he had in his slide, presumptive tests. So what is a presumptive test? It's a presumptive test. It's good for an analyst because you're looking for stained areas, might have a lot of DNA. But if, let's say, we do a presumptive blood test, the jury, and I want you to focus on the jury for your nephew, because he's now going to trial. The jury will hear, we did this, they'll hear in opening statements from the prosecutor about the blood sample that had his DNA, blood sample. The defense and prosecutor both say they'll finally put the analyst, the DNA analyst or serologist, on the stand, and they'll talk about, yeah, we did a Kesselmeyer test, and I want you to know there are false positives for that. Food, metals, saliva, pus, turmeric, which I had in our dinner last night. And but the jury's hearing blood, and all that counts is the jury. That is the client. That's the decider of fact. And so the jury's hearing blood, and then somebody in cross-examination usually asks the analyst, couldn't it be one of the false positives like fermented cabbage? And the analyst will answer honestly, it could be. It's just a screening test. And so then they'll hear in closing statements, the blood stain. Okay. What if we said instead, I did a test for fermented cabbage, I did a fermented cabbage test and a screening test for fermented cabbage, and there are some false positives with fermented cabbage. It could be blood. I was just looking for a biological stain. And a lot of analysts will say on this stand, I used the screening test to identify a biological stain to get DNA from. But do you see the difference? There's a wonderful book by the Nobel Prize winner Kahneman called Thinking Fast and Slow. And he goes through tools of bias in our brain to get to fast information. One of them is anchors. Once we imagine something, it's there. That is our neural root. If you say blood, I'm thinking blood. If I say cabbage, I'm thinking cabbage. Okay. What about for sperm? Well, I don't know if you guys do it, but in the US, we had DNA that we could separate, breaking open all the epithelial cells, and that was called the epithelial fraction, and we'd get the epithelial DNA. And then we'd spin down whatever didn't break open and dissolve with the mild treatment. And if there were sperm cells, they would be pelleted in the centrifuge. And now we treat them with harsh stinky chemicals that will break those disulfide bonds that hold the sperm head together. And, that breaking, it's like what we do with hair permanents, that stinky stuff. We take out the DNA from that second fraction, that if there was enough sperm cells, we'd get sperm cell DNA enriched in that second fraction. What's my problem with that? It's a great technique. We called it epithelial fraction, sperm fraction. If your nephew is accused and they take a sample from the vagina of the child, and there's little male DNA now in this case, and your nephew says, well, I did laundry, or I changed diapers, or she sat on my lap, I held her, I bathed her, whatever, his DNA might be in her intimate areas, but shouldn't be his sperm. So if the lab performs a differential extraction and gets a sperm fraction, and your nephew's in it in a tiny amount, but not in the epithelial, it looks like it's your nephew's sperm on the child's vaginal sample. What this paper showed was that in their lab, and I think labs have to validate this for themselves, there has to be at least 230 picograms of male DNA in that, what I'm referred to as the sperm fraction, the E2, the extraction 2. And at least half of the total male DNA must be in the E2 for them to be confident that there's sperm in what's called the sperm fraction. What did they do? This is a brilliant study. They had volunteers from the crime lab not have sex for 10 days with their consensual partners. Nothing. And then after 10 days, a specific act was performed, and that was that one partner gave the female, a female partner, oral sex, cunnilingus. So no sperm, right? If everybody was following the rules, and they're lab people, I'm trusting they did. And then the female who had received oral sex put on underwear the lab gave them, clean underwear, for various amounts of time. And then they took the underwear to the lab and did a extraction, a differential extraction, epithelial fraction, what some labs call sperm fraction. And here you see in the bottom, sperm fraction at the locus that tells us if there's male DNA, this little Y here, there's male DNA in that sperm fraction. There's no male DNA in the epithelial. Look at the profile. Here's the first locus right here. There's only two peaks in the epithelial. There's a third peak in the sperm fraction. This must have come from the male who gave us the Y, right? Because one way of thinking of it could have come from that male. We think that it did, and the lab knows that it did. So what's going on? Why are we getting from just oral sex male only in the sperm fraction? It's because when you get down to small amounts of DNA, that attempt to enrich for sperm might not work, but you might get carryover. You've eliminated the much of the female DNA in that first one, so you don't have overwhelming female DNA. Usually the female's much more, as you can see, female, the X chromosome's much more. Once you eliminate a lot of that, you start to see what may have been in here, but is seen in the panel from the sperm fraction. So this led them to conclude that you can get male DNA only in the sperm fraction, not the epithelial, and it's not from sperm. So I've waged a kind of battle with labs to stop using this terminology of sperm fraction. And it's easy enough to photograph sperm, right? Just take a picture, for goodness sakes. And some labs will just write, we saw sperm, or I saw sperm. That's not good enough. We need a photograph. This is serious. If someone in my lab said, I have evidence that someone who wrote us is innocent, there's a photograph that has sperm cells that proves they were innocent. And I'd say, well, there's not a photograph. I saw sperm cells under the microscope. I would say, where's the photo? And if they didn't take a photo, I don't believe them. I'm going to turn from this one. So these are just different lab reports from different dates showing you that back in 1999, we used to use sperm and non-sperm. In my own state of Idaho, 2018, even though I was complaining, they were using sperm cell fraction still. And now I'm happy to say they call it fraction 2 in Idaho. And I think that's a good enough name. All right, I mentioned the need for documentation. Should we just trust lab analysts? Well, what about in this country you don't know about? And a lab analyst says, I saw sperm on the slide from the vagina. Wouldn't you say, I'd like to see it? Can I see that photo? And they don't take a photo. And most states in the United States that I've worked in don't take photos. They don't take photos here in Idaho. It drives me crazy. I asked them, I'm like, don't you have cameras on all your microscopes? Yes. Aren't they hooked up to the computer? Yes. So it would be just a click, like no cost, just a click. Yes, but we don't have to take them. And so they don't. And I put down at the bottom of this, they photo parking violations. When a $25 ticket downtown, if I'm parked overtime or not parked correctly in the space, they take a picture. They send it to me. And I admit that I did it, especially seeing the picture. The pictures, even from an expert, you want to see the picture, certainly in the adversarial system where we're going to use this as evidence. I don't just want a note saying I saw sperm. I have to take a picture. We also need pictures of anything subjective done in the lab. If you say I saw it, there should be a picture. We take pictures of where the evidence has been cut, all kinds of things. So why not these colorimetric subjective tests? This is a positive and negative semen test in the state of Georgia in the United States. Here's the positive control. You see the positive control band in all of them, the test work. Here's the semen band. This is for P30 for folks who know about that. Here's the negative control. There's no semen band. Here's the evidence. Do you see a band there? Well, the analysts noted weak positive. And I believe they saw some color there. But the photo shows us that it was very weak, and it could be a false positive. Or it could be just a bad test. And here's again, from that case, thank goodness this lab takes photos so we could show the jury. There's the positive, there's the negative control. Here's the evidence. Well, it's a little pink in number 2, but look, the negative control's a little pink. That's why we need photos. And this is just a note from a Washington, D.C. Crime lab about testing with these antigens. And they say, you got to be very careful about the time. If you go over 10 minutes, everything's going to look positive. So you need to have your controls and your evidence, and you need to take a picture of that. Okay. Now, I think we can all identify these cells, right? We don't have to be experts. This is the Christmas tree stain of sperm. This is from a textbook. It looks beautiful, from a website that I have cited down below there. Here's actual evidence. And we can argue this is on the outside of a jacket that had been swabbed once, and then the police requested it be swabbed again to look for a sperm cell. And you can see there's debris in there, and there's one cell. It has no tail, but it has some of the features of a sperm, that kind of eyelid look. And I blew it up here, but there's also a lot of junk on there. And this is an outdoor jacket. Pollens can look like sperm cells, etc. So I was glad we had a photo. We could show it to the jury. The analysts could describe what they saw. And I thought that was a very fair way to do it. But the labs that don't take photos and just say they found sperm, that's not evidence. That's opinion. Show me the evidence. More accidental terms. And again, remember, this is your nephew. He's been accused of either digitally or with his penis penetrating a child who can't speak, too young. And so the lab might say, we took an internal vaginal swab and we found his DNA internal vaginal. Wow, that sounds convincing. However, swabs and speculums can carry DNA into an orifice. How do I know this? The only paper I could find on it. Remember, I'm testifying to the field's view, not my anecdotal personal experience. The courts allow me to testify about my anecdotal. I try to stay away from that. I go to the validated, the peer-reviewed literature. And so here they're talking about Locard's principle. We all know about that. You leave something every time you have contact or go somewhere, and you take something away with you. And they wanted to say, what about these vaginal samples? So they did a very interesting, I thought, wonderful experiment. They designed plastic vaginas, or silicone vaginas, I think, different sizes for child and adult. And they tested whether a speculum or finger dilation, putting the swab into this orifice, this artificial orifice, if you carried stuff in when you put in the swab or the speculum. That's a really good question. I wouldn't know what the answer is. That's why I love controlled science. In lab, when we do experiments, we all guess what the outcome will be, and then we find out. Because that's the fun part of science, knowing that you don't know the answer. So guess what happened? Well, they used powders to test whether they could get in without dragging stuff in from the outside. And they found in 100% of the speculum cases, they brought material in. And in 80 something percent of the manual dilation with a swab. I would have thought speculum was better, so I was wrong. They invented a sleeve, just looks like kind of a baggie with the seam cut out of it, so an open plastic sleeve that you could go through. And their sleeve worked very well, but I don't know anybody who's using a sleeve. That would be much better. Yet, the evidence introduced, the jury hears in opening statements, in closing, from the experts, in testimony, that this is an internal vaginal sample. It was an attempt, certainly an honest attempt, in a terrible situation, a terrible allegation, to get an internal vaginal sample. But the name anchors, according to Kahneman, what we're thinking. Internal vaginal, boy, that's pretty convincing, until I think you look at the data and see, well, his DNA could have been carried in if he was changing diapers and he left something on the child's, around the child's vagina or on it. It could have been brought in. Did it happen that way? I don't know, but I think it's important to see that, according to the one learned treatise, we can expect to transfer material in when swabbing or using a speculum. Bias is a big word. I've told you about this anchoring phenomena. When you first hear something or you imagine a scenario, it's anchored in your mind. And but there are other forms of bias, and I've published on bias in DNA mixture interpretation with Itiel Dror. This is another paper that Itiel published with a team of people, and this was forensic pathologists, medical doctors who are trained in forensics, who decide whether the evidence is evidence of an accidental death or a homicide. So what Itiel did brilliantly was to give the exact same medical information to pathologists in two groups. One group, represented by the white bars, was given the same evidence, but was told the child who died, the child was left, the child was white and was left with their maternal grandmother. And in that case, with that medical evidence, they found accident about 28% of the time. The black represents the same medical evidence, but the forensic pathologists were told that it was a black child in the care of the mother's boyfriend. Now, right away, I think everybody sees there's a couple of variables, two variables there. That wasn't Itiel's point. And the author's point. The author's point was the contextual bias that we have influences us. This paper in the Journal of Forensic Science got more letters than any other paper in the history of the journal, so many so that the journal editor wrote their own letter, an editorial, in the next issue, saying, I've never seen anything like this. Usually we handle these discussions calmly. I know that the authors had to respond to about 20 different complaint letters. And what some of the pathologists said is, oh no, it's okay to use that information because that information, statistically might be relevant. Who was with the child? And no one addressed the race question, I think, because it's a very charged topic. But they did address the idea, well, it's the mother of the child is less likely to kill than a boyfriend. And I don't know where they got those statistics or how you would do the controls, but this shows us that contextual information is being used throughout forensics, some accidentally, some with defense, defending the idea. So we did the same. with a complex mixture for a client named Kerry Robinson in Georgia. And I spent an awful lot of time. And I thought we came up with the most creative things we've done to try to find answers. Anyway, one of the things we did was to take the evidence from the case. It was a case where a woman had been raped by 3 or more men who left semen evidence. And she picked out from a high school yearbook or a middle school yearbook one of the guys. And that guy, his DNA's, I think, clearly here. But he was offered a lower sentence, a deal, if he would name one of the other guys or the other guys. And so he gave them a name, Kerry Robinson. Kerry said he called me out because he thought I ratted him out to the police. So this is the mixture DNA. What we did was to try to show that the expert in Georgia who said, yeah, Kerry Robinson can't be excluded from this mixture, that expert was wrong. And so one of the ways I did this, I tried a lot of things. One of the ways we did it was to take that same evidence and give it to 17 analysts at another crime lab. We did a controlled study and we published it in a peer-reviewed journal. And out of the 17 examiners, only one agreed with the Georgia expert. And what was interesting is these people are all at the same crime lab. And yet we got all 3 possible conclusions. Kerry's included, one person said. Kerry's excluded, 13 said. And inconclusive, 3 said. And it shows you that we're at the borderlines of science here, where experts trained with the same methods are getting all 3 answers. Unfortunately, most cases have one expert. And disagreements in the lab, if there are disagreements, are often not disclosed to the defense. That I hope that will change. Okay, that was our conclusion from that. And I asked the lawyer to write to the head of the Georgia lab that had helped convict Kerry Robinson. Well, when would you exclude Kerry? And what we got as an answer is that even if there are no alleles in the evidence that are consistent with the subject, no alleles, no DNA consistent with, this does not constitute a conclusive exclusion of the subject, since the absence of evidence is not equivalent to the evidence of absence. Unbelievable. Now I understand, and John Butler talked about this. If you have dropout, you'd have a hard time making conclusive statements. But imagine what this is for your nephew. If there's dropout, they're going to say they couldn't exclude him, and that was used by the Georgia experts. I could not exclude. That same language, cannot exclude, means a match. Most labs use cannot exclude as a match, but in English, you could use cannot exclude for we can't absolutely exclude. It's inconclusive. So they were using the same language basically for, I think, inconclusive and cannot exclude. Okay. I wrote about one of John's studies that I criticized, John Butler's studies. And again, this is not a criticism of John, but this DNA mix study that was done, I won't get into it here. You can read my piece in the New York Times. You can read John's publication that's referred to in there. And basically, though, it showed that with a really hard question that they designed, that NIST designed and sent out to crime labs, 74 of the 108 crime labs said someone is included and gave a statistic to a mixed DNA profile, where the lab had designed that this person wasn't included. It was a difficult problem. And the point is, labs didn't know when to quit, like when to say, we can't tell. We can't discriminate between the possibilities. And it seemed to me that they were in a indecisive evidence case. They were deciding for inclusion incorrectly. So we started using probabilistic genotyping. to look at old cases where things were either inconclusive or weakly inclusive, and we've now freed more than 10 people using probabilistic genotyping. This was the first one. Unfortunately, Daryl Pinkins died a few months ago. He was never compensated. He did 25 years in prison. I'd like to show you Kerry Robinson did get out. Finally, that the man that we did that mixed DNA mixture bias problem. And the only reason I think he was freed was that the state of Georgia bought a program called TrueAllele to do probabilistic genotyping. When I requested that they use it to go back and look at this evidence, they said, oh, we can't. We didn't validate it for the old chemistry. And so I really didn't know what to do after working this case more than a decade. And I wrote to my friend, who actually is the guy who created the software that Georgia bought. And I said, could you use your software to look at an old case? He said, yes. He excluded Kerry. They let Kerry out. So that was Mark Perlin with TrueAllele. Okay. I'm going to skip this because we're near the end. And I'm just going to go to what I consider sensitivity, what I consider the important. That's Amanda Knox. I'm going to be speaking with her in Italy. As John referred to, she was wrongly convicted with bad DNA. That was my first DNA, the first time that we overturned a DNA a conviction. It was in Italy, and I didn't do the bulk of the work that was done by great folks in Italy, but I was part of the group in the US and did go to Italy to pick up the data and such, but she had a great team. And here are the solutions. First one is DNA analysts in every lab should be like in Henry Lee's lab in Connecticut, encouraged to privately consult on out-of-state cases. I privately consult. I get paid to look at cases of people who are going to trial. Some of my friends who are in crime labs are allowed to do that, and some crime labs don't allow them to do it or make it impossible. That's terrible for the system. We should demonstrate that you have equal access to all of the experts, whether you're in the state or out of state, or whether it's for the prosecution or the defense. If the defense has to rely on academic experts like me or other experts, I think that's unfair. So I want to encourage people who run crime labs to look into this. And if you want to talk to me about it, I can talk to you about it. I think it's really important to the system. It's what makes me better at what I do because I travel all over and I see how different labs do things. I won't get through the rules of evidence. I talked to most of that. Broad scientific professional development, not just forensic science. And that's because we were able to, Charles Fain, who was on death row in Idaho, was freed with DNA evidence. We helped pass a law that got him and Chris compensated. And then I met a man who does ancient DNA work. And I asked him, can you look at a pubic hair? And we do genealogy. That led to the formation of a company called Estrella that Ed Green now heads up. And the first case using this ancient DNA technique on pubic hair is going on right now. Next week, he'll testify here in Idaho. But that's how Estrella got started. So I'll leave it with that. This is Charles Fain. He's bought a truck after being in prison on death row. He was 4 hours from execution at one point, and we got him compensated. This is my book with Calvin Johnson, who also passed away this year. I'm going to a memorial this weekend for him. But if you want to get in touch with me, forensic DNA analysis at gmail.com. I like to make friends. So get in touch. And some of you I know already. I know certainly Martine is in the audience today. So you're all invited. I'd love to discuss DNA with you anytime. Thanks.
Uh, Thank you, Greg, for your wonderful presentation. I think we have time for maybe just one question. Um, I'm going to. I don't know if it is possible that I write the question in the chat, uh,
Oh,
so you can read it and answer
yeah.
it. So, yes.
Okay. Yeah,
Okay.
let's see.
Okay.
Um,
So hold on. Uh, and so I just word it.
absolute truth, regulatory changes. I mean, I think that the most important thing is that we as scientists make a clear statement about the limits of what we know. And we as scientists, like I had a question about the speculum and the squab, look up the research and present the research. Stick within the research. Do not be, if somebody wants you to say, could this DNA have gotten there this way? They want you to do a is it possible question. You have to answer that. But I always try to start with, look, when I talk about the possible, there are infinite possibilities. You know, it could be George Washington's DNA was left at the scene and I didn't find it. So I don't want to endorse any possibility. I'll answer your questions, but just saying something is possible is meaningless, except that it's non-zero, that the probability is non-zero, but I can't give it a weight. So I think we as scientists need to say we're not going to do this anymore. We're not going to mislead the triers of fact. These honest, hardworking jurors or the judges who are there, also honest and hardworking. We're not going to mislead them with terms like presumptive blood test, call it blood all the time, or semen fraction or sperm fraction when we haven't photographed sperms. We have to decide. You got to take pictures. We're going to take pictures because it's good science. In any other lab, we would be required to take pictures of our results. I hope that answers that.
Okay. Yes. Gracias. La pregunta trata, perdón por no decirla en español, pero es acerca de considerando la prueba genética como una verdad absoluta en muchos juicios, qué cambios y políticas y regulaciones se tendrían que hacer para mejorar la precisión, equidad y evitar estos sesgos que ocurren con este tipo de pruebas en los juicios. Otra pregunta que quieran hacer, y en caso de que no, bueno, ya tienen el contacto de Greg. La verdad es una persona bastante accesible y yo creo que les contestará sus correos muy felizmente. So, Greg, I guess this is the end of your talk, with your presentation. Thanks again for accepting our invitation. We were glad that uh, to have you here. I hope, as you invited us to your lab, I hope at some moment you can
Oh,
travel to Mexico uh,
oh,
to to visit us, maybe in the
I,
future.
I can't wait, and this was a great honor. Love to work with any of you anytime. Thank you.
Okay, so see you around. We keep in touch. So see ya.
Bye bye.